We're live. Good evening. I'm attorney Vincent Davis, and this is The Secret, How to Fight CPS and Win. I'm joined by some very special guests. We have Miss Cassandra Woodard. Good evening, Cassandra. How are you?
Good. How are you?
Good. And then we have Miss Georgette Truen. Miss G, how are you doing tonight?
Fabulous, just fabulous. I have the wonderful boss that anyone, I'm so blessed. So blessed. So blessed.
Are
My
you are
boss
you
is
ge-
awesome.
are you genuflecting when you say that?
That's for me to know, for you to find out.
All right, and we have a very special guest, Miss Landy Woods. Landy, how are you?
I'm doing well, thank you. And I wanted to take a special moment to thank you, Vince and Miss G. You guys are amazing. You're putting out such great information for people. I am so blessed to be able to find you, and I've been studying you for the last month or two.
Thank you.
Very good, very good. Have you liked and subscribed to my YouTube channel?
That's how I found you. That's all I've found so far. You're probably on Facebook too and other.
Mm-hmm.
Okay, I'll look around, find you more.
All
Thank you.
right.
Yeah, I do have a couple questions. My first question, thank you so much. Well, I need to cancel. I'm in the investigatory phase of a CPS. It's not a case yet, so we're still in investigation. And I'm trying to cancel 4 things. I need to cancel cash aid. I need to cancel their welfare to work program, which is called Equus down here in Southern California. I did say that I would need childcare. I want to cancel that. And I also need to try to somehow cancel. We've actually gotten a packet, both my man and I, that we're being sued by child welfare services to basically, I think what it is they're going after their dad for the cash aid I've been getting. So I want to cancel this gracefully and to not flag CPS to come out and check us again, and hopefully for them to not come after JR. So sorry. So want to cancel everything. I've been learning a little bit about common law and other jurisdictions of law besides statutory admiralty that the main commerce is going in. So
Time out. Stop. Okay, so you asked me a question. Let me answer the question before we go on to the next topic you wanted to talk about.
thank you.
So you mentioned you're in California. So in California, welfare benefits are not tied to CPS. So let me give you an example. In Los Angeles County, if you wanted to receive benefits like cash aid or Medi-Cal or something like that, you would be getting that from the Department of Social Services.
Okay.
CPS in Los Angeles County is called the Department of Children and Family Services.
Mm-hmm.
2 totally different departments. Can they and do they share information? Yes. But they don't have anything to do with each other. Okay, so you can cancel anything you want, and that doesn't give rise to a DC or a CPS investigation. Okay?
Okay. Yeah, it was just kind of odd timing then, because they wanted me, because I've been getting the cash aid for 3 months, and then they wanted me to sign a new contract. And so I've been learning more about, contract law and things like that. And I want to rescind my signatures in such a way that doesn't flag CPS. You know what I'm
Yeah.
saying?
You canceling won't flag CPS for anything.
Okay.
The only thing that flags CPS is if someone reports you for child abuse or suspected child abuse.
Or
That has,
neglect.
that has nothing to do with cash aid.
Okay.
All right. Now, before we go on to your second topic, I want to tell you something, okay?
Okay.
This is my 36th year as a lawyer. Okay. Are you even 36 years old?
Thank you. I'm in my 40s.
Okay. I've done these cases at the appellate level, at the trial court level, at the investigative stage before a case even starts.
Hmm.
Okay. I've sued social workers and counties for civil rights violations in federal court. All right. So, although I don't know everything, I know a lot and I'm experienced. The reason why I'm telling you this is because your next topic that you seem to be going into is, I don't know how to say this in a nicer way, but it's a scam. Okay. It has nothing to do with the law in these courts. And I have seen people bring it up in some of these cases, and they're basically laughed out of court. So don't go down that road. Okay. So you were about to tell me about federal common law and admiralty and all that stuff. Okay. The
I can
reason why
move on.
the reason why I called it a scam because there was a guy on the internet selling a course, kind of like a secret course to people
Mm-hmm.
about how you could use these types of arguments to win your case. And a guy hired me in Northern California to defend him in a CPS case. But one of his stipulations after he hired me was that I use this playbook from this person he bought it from on the internet about federal common law and admiralty and all of that. And I refused to do it. And he told me that I was fired. No problem. I went on.
Yeah.
About 6 months later, he contacted me again. And basically, he said, Mr. Davis, I'm so sorry that I fired you. And I'm so sorry that I didn't listen to you.
Mm-hmm.
He told me I was laughed out of court, right? And then he said he tried to appeal it, and an appellate lawyer that he hired or was going to hire told him, this is all a sham. So I can't even represent you on appeal in this because it's all just a sham.
Mm-hmm.
Okay. So
Hmm.
if you want to talk about it, let's talk about it. But most people that I talk about federal common law don't know what they're talking about. There is a
I'm
such
no
thing as
expert. I'm
there
no
is,
expert for sure.
but let me tell you
Definitely
this:
to
there
learn.
is such a thing as federal common law. It has nothing to do with the defense of a CPS case. Okay,
It's more
it would.
about invoking your rights in the beginning when they first start trying to come talk to you. You have to know really how to stand as a living, breathing woman or man and assert your rights. Because if you don't really assert your rights, then you really have none.
Well, here's what you need to know at the beginning of a CPS case when they start the investigation. Don't talk to social workers without an attorney.
Right.
That's it. Next. But see, most people don't talk to social workers because they don't know about their rights. That's not why they talk to social workers. They talk to social workers because they think they can outsmart and outtalk and outreason the social worker, not knowing that this social worker is a highly trained individual.
Right.
Okay. And then they start talking, blah, blah, blah. And then it comes back to bite them in the butt. So it's not about,
Absolutely.
I didn't know my rights. It's about, look, everyone sees television and movies and people lawyering up, right? Well, when they come talk to you about your child, probably the most important thing in your life, why do you, why don't you lawyer up? If they were going to accuse you of robbing the bank, you'd know to lawyer up. So when they come to talk to you about abuse or neglect of your own child, why aren't you lawyering up? And by the way, when you talk to a social worker, that social worker can come testify against you in a criminal case. So there is no reason you should be talking to a social worker without your lawyer being present. Now,
Right.
notice that last part, without your lawyer being present. I didn't say don't talk to social workers.
Right.
I said don't talk to social workers without your lawyer being present. Now, will there ever be attorneys and perhaps judicial officers that disagree with me? Yes, for sure. I'm just giving you my professional opinion after doing this almost over 30 years, thousands of cases.
Right.
Okay, so if you want to talk to the social worker, go ahead.
No, I definitely don't want to talk to the social worker. I'm trying to, get my ducks in a row, I guess, of what I would say. So they come up and they, knock on the door. You just don't open it, right? And they may leave their card, but everything's offer and acceptance and agreements and contracts, written, nonverbal, simple, complex. And so even accepting their business card is kind of a little bit engaging with them and accepting their offer. They're offering for you to take their business card and maybe even call them or have my attorney call them. So I guess don't answer the door. They keep leaving like their card. What would happen? Like they just keep coming back until we're outside? Is that
You
kind of how
know,
it goes?
probably it depends on the social worker. It depends on what the accusations are. You know, I had two children, um, and when the kids were about maybe 3 or 4, I found a card of a DCFS social worker on my screen door. I was She was coming to investigate me and my then wife, who's now deceased, for child abuse. So I was doing this type of law at the time. I invited her in and to come talk to me because there were things that I wanted to find out from her. Now, you've seen those things on TV. Don't try this at home. I'm not suggesting that any of you try this yourself,
Okay.
right? What you should be doing is calling a lawyer and asking him or her advice. Now, sometimes when you call a lawyer, the lawyer will tell you, oh, cooperate with CPS, talk to them, do everything they want you to do. Is that a strategy? Yes, it's a strategy. It's not a strategy I agree with, but it's a
Right.
strategy, right? So, that's why they call it the practice of law. Everybody has their own beliefs in what's going down in these cases. So, call your attorney. That's what you should be doing. And here's what you shouldn't be doing, Landy, and you're doing this. You're trying to figure it out for yourself. Does that
Trying
ever
to be
work?
prepared.
Does
Trying to
that
be
ever
prepared.
does that ever work? Yes, it
Probably
does.
not. Maybe sometimes.
Yeah, sometimes. Like 1 out of 1,000. What you should do is go talk to someone in your area that practices, CPS or juvenile dependency law and have a consultation, free consultation or something.
Right. Okay. I'd like
You
to
know,
hire you if I ever need to.
Landy, let me ask you something. Here's a scenario for you. You just went to the doctor. Okay, you went to the doctor today. And the doctor she told you, hey, Landy, you need open heart surgery.
Right.
Okay.
I wouldn't go try to figure out open heart surgery. I watched your
Why?
videos, Vince.
Why? Why wouldn't you do that?
I'm
Because
no expert.
you're gonna end up dead.
Yeah.
But everybody thinks that they can figure this thing out. let me tell you something. Lawyers come to me because this system is so different.
Yeah.
There's so many different rules and exceptions. So don't try to figure it out for yourself. Become generally familiar, but don't create a strategy. Go talk to a lawyer.
Okay. Okay. So in the investigatory phase, I was hearing from you that they either need a warrant, a court order, or extenuating circumstances to enter your home, and they may or may not have law enforcement with them. So I've heard that there are a lot
No,
of fake
no,
warrants out there.
no. Hold on a second before you go on to the
Okay.
next one. That's not what
Okay.
I said.
Oh,
I
I'm
said some,
sorry.
I said some,
Other people.
I've said something close to that, but I'm a lawyer, so let's get it correct.
Okay.
Number one, they can never get a warrant to talk to you.
Right.
Never.
To come in and investigate.
They can get a warrant to come into your home. They can get a warrant to talk to your kids, and they can get a warrant to take your children away from you. And if they don't have a warrant, they can have something called exigent circumstances.
Exigent.
Now, that's specifically defined in the law. It's basically emergency, kind of a life or death situation. Okay. Are there ever exigent circumstances? Yes, but it's rare.
Right.
That's why if they're coming to your home to take your kids, they need a warrant, or they
Right.
violate the Fourth
And
Amendment
excuse me.
of the Constitution.
Right. And doesn't that warrant need to have a wedding signature from a judge?
Have a what signature?
Wet ink with their pen and not a stamp.
No.
Can be any warrant, any piece of paper that they say is a warrant.
Well, it can be a warrant with the judge's signature. And it doesn't have to be wet ink. It could be, they're using now computerized facsimile, digital
Right.
signatures. But what you should do is you should get a copy of the warrant when they give it to you. Keep it.
Right.
Have I ever heard them using fake warrants? Yeah, I've heard of that.
Mm-hmm.
Have you ever heard anybody using fake anything? Yeah, all the time. So why do you think, social workers are immune from trying something like that? They're not.
Right.
And I still get stories from people that they come in and take their kids without a warrant. I still hear that.
We
Even
have the
today.
warrant. You'll get it later, they'll say, if you ask for it.
Right.
They need to have it, right? They can come back when they have one. So, if I may, what does a court order physically look like?
Piece of paper with usually typed with some judge's signature. They all look different. You're in California. I can tell you I've seen warrants from many counties in California. There are 57 or 58 counties. And you know what? They all look different.
Okay.
So it's not going to be like $100 bill. They all look the same. No.
Yeah.
They all look different. And if an officer or an agent of the government tells you this is a valid warrant, I suggest you take their word for it. Because if
what
it
else can I
is,
do?
yeah, if it is and you don't, guess who's getting arrested?
Mm-hmm.
The handcuffs. So
Right. So
you can't tell a fake one from a non-fake one, but you should
okay.
get a copy.
It's crazy. You would exchange a piece of paper for your kids. I just can't even. Okay. So my next.
I didn't say it was a good idea. I'm just a messenger. I'm just telling you what, in my opinion, the law is.
Right. And then with the exigent circumstance, that's a matter of opinion, really. I mean, what do I say? Do you hear anybody crying? No, everyone's actually fed. I mean, that's me talking to them.
Wait, hold on, Mandy. You can't say anything. Don't say
Right.
anything. All right. You keep your mouth closed because you will be misquoted.
Yeah.
All right. And it will be used against you.
So really the first thing to do is get out your video camera and tell them you're recording.
That's a great idea.
Yeah.
Before cell phones became really, really popular, I had a client who videotaped everything when they came to detain his kid. And as it turned out, it helped us in the case because the social worker was claiming that my client said certain things about running off with the kids.
Mhm.
And that's one of the reasons why they detained the kids. But as it turned out, when you watch the video, he never said anything about it, about running off with the kids to Mexico.
Mhm.
Never, and nothing like that.
Right.
The social worker had just not been truthful. In that particular case, the mother was the alleged culprit. My guy would be what they call non-offending, and they were going to take the kids from him because he threatened to run to Mexico. Well, when you look at the video, he never threatened. And the only reason why the video was allowed to be in evidence because it was obvious that he was videotaping everybody. He didn't tell anybody, but he had the camera right there. In those days, it was a camera, right?
Yeah.
Today, it's your cell phone. Everybody has a video camera on their cell phone. High
Right.
quality, I might add. High quality pictures.
I was hearing that from someone else that 80% of the removals in their state, this was Minnesota, was for non-physical accusations or allegations. So that's 80%, which would be mental and emotional concerns. So
No, not necessarily.
what else could it be?
It could be mom and dad had a domestic violence incident where the kids were in the bedroom.
Mm-hmm.
Mom's a drug addict. Dad's a drug addict. Alcoholic. I mean, I could go on and on.
Okay. Well, in the
So
case, true. In the case that it's
rarely,
a,
rarely, I'd say 1 out of 5 times, maybe 2 out of 5 times, do I see a case where the kids have been removed and something happened to the kids. Usually it's not that the kid's been abused, but there's a risk of abuse, especially, in drug cases and alcohol cases. Nothing happened to the kid. Just mom tested positive at the time of birth. Now, do I think they should be able to remove kids just for that? No, I don't. Do they? Yes, every day. Thousands every day.
okay, thank you. So if the allegations are some kind of emotional or mental concerns on the mom or dad, would a potential strategy be in the investigatory phase and throughout the case to invoke your ADA rights? If they're saying that you have some sort of disability or emotional concern, you know, why not invoke the ADA and have an advocate for you? I mean, that would be a potential strategy, am I correct?
It is a potential strategy. Is it a good strategy? I don't know. It depends on the facts and circumstances. See and we talked about this earlier about federal civil law. You're trying to find a defense that's going to help you in the CPS case, and you're looking in the wrong place. You see, here's a concept that I found really hard to accept, but I've accepted it because it is the law. Let's say they come to your house and take your kids without a warrant, without exigent circumstances. And you go to court and you argue that no, your Fourth Amendment rights have been violated. You know what the juvenile court judge is going to say? Too bad, so sad. It's not a defense in juvenile court. Now, it will be something you can sue them about later in another courthouse, in another courtroom with another judge under different laws. But it's not like criminal law where, they do something illegal and it could get you totally off the case, out of the charges. It's not like that. It's not a criminal case. They view you losing your child less than you going to jail. And as a matter of fact, it's probably the other way around for most people. They don't care about going to jail. They do care about losing their kids. But yet we give criminals more legal protection in the court than we do parents who are losing their kids. That's one of in my humble opinion, one of the fundamental problems of CPS laws.
Mhm.
We don't give enough importance. And it's interesting because the Supreme Court of the United States, over many years in different courts and different justices have said that being a parent is one of your most important constitutional rights. Yet,
Right.
yet when you go to CPS court, it's not, when 20 years ago, when I used to do cases as a court appointed attorney, there was an inside joke. And the joke was, does the Constitution even apply in CPS courtrooms?
That is so not funny.
Right.
Mm-mm.
Right. Like the Constitution doesn't apply? Well, not really.
Because they set rules in place to violate your rights.
But government is like that for the most part in every aspect of our life. They're constantly doing things and we're constantly scratching our heads saying, doesn't that violate the Constitution? Like, how many times have you seen that on the news in non-CPS related matters? All the time, every day. I mean, it's a great thing that we have the Constitution because it's there to protect us. But it doesn't provide absolute protection in every type of case. And most people think that it does, and unfortunately it doesn't. Now, I'm just the messenger, right? So there's a couple of attorneys that I know that have, when your ADA rights have been violated, you can sue in federal court or state court here in California. You can sue. But that doesn't mean you can use it as a defense to get your kids back. And I know
Right.
to me, that was like, what? That doesn't even make sense. That's me 20 years ago. Like, this doesn't make sense. But
Right.
unfortunately, that's the law.
So getting your kids back, you focus on evidence. And one of the maxims of law is the spoken word flies out the window, but written words last forever.
That's true. And by the way, you focus on the admissible evidence. Everything is evidence, but it doesn't mean that it gets to come inside the courtroom. Only competent and admissible evidence gets to come in. Now, do you know what competent evidence is? Do you know what admissible evidence is? You probably don't. You know why?
I'd have to study the rules of evidence for California.
I've been a lawyer 36 years now, going on 36. I'm still learning the rules of evidence.
Wow. Yeah. Better get on it, Vince.
That's how complex and how things change and how things are subtly changed under case law all the time.
It's always a moving target, Yeah. This is this is commerce. They're making money. There's bonds. There's many bonds for every criminal or offense case. There's multiple bonds, and who's making the money? It's not you. It's not me.
Yeah. Landy, here's something somebody told me once about the rules of evidence. You can learn the rules of evidence in a week. It will take you a lifetime to master.
Yeah.
A lifetime to master. People think that, evidence is just common sense. It's far from common sense.
Yep.
And you know what? I didn't write the rules of evidence. I didn't decide any appellate cases on the rules of evidence. But I try to use those rules and cases to help my clients win.
Right.
I'm going to tell you right now a very important case in California. It's called People versus Sanchez. Okay, it's a criminal case. And it has to do with the admissibility of hearsay evidence, specifically in the form of a psychological evaluation, generally in California under Evidence Code 730. For years, hearsay statements made in the report were admissible. Totem pole or multiple hearsay mentioned in a 730 evaluation by some PhD, it was admissible. I never understood that exception. And finally, a few years ago, in People v. Sanchez, the Supreme Court said, hold on. That hearsay and multiple hearsay in these reports, it's not admissible. It's hearsay. It violates the defendant's constitutional rights, among other things, to confront and cross-examine. And then the family law court in California said, oh, yeah, it's not admissible. Because, in family law, in custody and visitation cases, they're always doing 730 evaluations regarding custody and visitation. And then they said, oh, yeah, we can't use those reports, that hearsay. But you gotta specifically and carefully, under the rules, object in the right way to keep it out. So first of all, there's a level or hurdle you have to jump over. So you can't just say, oh, it's hearsay, objection. You got to do it the right way. Give the people the notice. And then guess where else they use 730 evaluations all the time? CPS courts, juvenile dependency courts. And then lo and behold, there's that one appellate case that comes out and says, oh, People v. Sanchez, that doesn't apply to CPS cases. Like, what?
No way.
Right. Doesn't apply to CPS cases. Thank you very much. So you parents, you continue to get the short end of the stick on the evidence meter.
Gotcha.
So,
thank you for that.
You got to know these rules. I haven't looked at the code in this particular section in years, but there used to be a code section that said something like this, that the social worker had to prove a case against you the same way you'd have to prove a case in regular civil court. In other words, the rules of evidence apply. There's no special exceptions. You got to have some real evidence. In a lot of cases, it's not even that. It's exactly opposite of that. There's something called the preponderance of evidence. They have to prove today that by preponderance of evidence that you have abused or at risk of abusing your child. Well, the old joke was, 20 years ago, it's not a preponderance of evidence. It's a scintilla of evidence. You know what a scintilla is, Landy?
I don't.
A scintilla is a grain of sand on the beach. And
Gotcha.
the joke was, all the social worker needed was a grain of sand on the scale to prove the case against you at the jurisdictional phase of the case. Now, that's what a lot of defense lawyers thought 20 years ago. Do they think this now? I don't know. Sometimes I get that feeling, and I get the feeling that a lot of times credibility automatically is given to the social worker and not to the parent. It's just assumed that they're not lying, they're telling the truth, which, by the
What's that?
way, is a bad assumption, in my opinion.
Yeah. Qualified immunity, right?
Well, if they lie and you prove it, they don't have qualified immunity. Although they argued that in Orange County in a Ninth Circuit case you can watch on YouTube, where some poor woman attorney tried to argue to 3 conservative justices, by the way, that social workers should be immune for lying in court. They basically laughed her out of the courtroom.
Good.
So, things are tough for parents in these CPS cases. And
It
in
sounds like
my opinion, there's a lot of reasons for that. A lot of reasons. If it were up to me, I'd make laws a little bit different. I'd maybe keep them the same and let these people have jury trials. Let 12 people or 10 people or even 6 people decide who's telling the truth.
And constitutionally, it's supposed to be a jury of your peers. It's supposed to be people who actually know your character.
That's not
I
true.
know.
No,
No.
that's what you think. That's not the law. That's the law for a criminal case. Whether
Criminal.
you have when you're going to jail. Like I said earlier, we give criminals more rights than we do parents.
I know. Why are parents guilty until proven innocent? That's so not fair. Doing the best we can here.
I don't know. I think for some reason the state believes that protecting children far outweighs your rights as a parent. And we could have, a 10-hour discussion on that.
Yeah.
But, as I tell GT or Miss G all the time and Cassandra, look, if you don't like the law, don't call me up to complain about it. Do something.
Right.
Go vote. Go organize. Go get petitions signed. Change the law. But you calling me up and ranting for an hour about how you got screwed over, that's not going to help you.
Right. You got to rally the people. You're right.
You got to get to vote.
Yep. We also need more good people to run for office. So, Attorney Vince.
There's a lot of people out there that will do it. But you got to have the right, state of mind and framework.
Well, you have my vote.
Oh, you're so kind, but I'm not. I'm hardly qualified. I spent my career defending people, and I have a posture towards not being objective, so to speak, because I think parents are always right.
Aw, because they hire you.
But are they always right? No. The problem is that these laws were made to protect children, which is a noble and important thing.
It is.
And is there ever child abuse out there?
Of course.
Yes.
Right.
But the way they use the laws against parents, where there may be little or no child abuse, has gone overboard. It's gone overboard.
It has.
And I think it's time to reset, to rethink what we're doing.
Absolutely. Yeah, I got into studying CPS and whatnot right at the beginning of the pandemic. I had a friend who had 3 little girls taken from her, and one of them was a nursling. She was barely a year old, and they took away her immunity, her nutrition, cold turkey, and then it was COVID, so couldn't have visitation and all that. I won't get into my friend, but when that happened to her, I'm like, I got to figure this out. I got to know what I would say and do if they do come a knocking. So if they do come a knocking, if you don't mind, I have one more question about the investigatory phase. So let's say they come and the social worker has law enforcement. Would a potential strategy, if they won't leave, be for me to call my own law enforcement to kind of be more on my side? Like if they're demanding to come in, would that be a potential strategy? I got 2 no's from the ladies.
No, no. I mean, listen, it's a strategy, and in my opinion, it's a bad strategy.
Okay.
Okay.
So just let them come in and take the
No,
kids.
no, 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 no. Well, wait a
Okay.
minute. First of all, do they have a warrant?
Well, right. Let's say they have a piece of paper and they're calling it a warrant.
And it says we're here to pick up your kids. Yeah, you're going to have to give them the kids because they're going to win that battle. You know why?
Because they have
Because
guns and badges and
right,
all the money backing them, and I don't.
right, exactly.
Yep.
You'll see 12 cops outside with shotguns and guns trying to take your child because it was alleged you had a dirty drug test at the hospital.
Crazy.
Now, is that right? No, I don't think it is, but that's what happens.
Right.
And as a society, we all let it happen. You know why? Because nobody here, including me, has organized people to vote against this.
The masses are waking. I do think we're hitting that critical mass of people who
I,
are
I think we're
ready to
getting there.
make changes.
I
I
think
do.
we're getting there. Enough people have been, at least they feel they've been screwed over,
Right.
and they're starting to shake their head, and it's going to affect elections. It's going to affect how people vote for legislators, how they vote for judges. In California, I don't know if you know this, but judges are elected or appointed, and if they're appointed or elected, they have to face re-election. So
Hmm.
they're going to they have to face a vote sometimes. It's just that people don't think about voting for judges. I was having a conversation with a friend who's not a lawyer recently, and he told me that, in every election in the county, I've never voted for a judge. And I said, well, what do you do on the ballot? Oh, I just skip it. I just skip it.
Mm.
I mean, and that's his right, as a voter. But maybe we should be doing something to help educate him so that he will make better decisions
Hmm.
or at least vote on everybody on the ballot.
Right. I have another friend with an open case up in Northern California, and it's recent. I wanted to call into court and be a witness during the first couple hearings, and I was able to find all these other courtrooms call-in numbers, but hers was not available. And she asked her court-appointed attorney later, and he said, "Oh yeah, this judge says only immediate family members."
Well, that's the law. You, fortunately or unfortunately, these cases are confidential, so the public can't come in.
What if I'm not really the public? What if I'm a close friend of her family?
You're the public.
What, really? Nephrom, non-family, what is it again?
That's to take care of a child, not to be a
Okay.
witness.
Okay.
So be careful when you're dealing with the law. Don't scramble concepts
Yeah.
together. Okay. Nephrim has nothing to do with whether you can be in the courtroom.
Okay.
So
Unless
by law, you're not supposed to be in the courtroom
okay.
unless you're going to be on the witness stand, and you're only there in the courtroom as a witness when you're testifying under oath, under penalty of perjury.
Okay. And that's not for all cases. That's just these juvenile dependency.
Right. Just for
Okay.
CPS juvenile dependency cases.
Okay.
Criminal cases or civil case, you can go walk in the courtroom, sit down and watch everything. Which was, by the way, one of the important checks and balances in our judicial system. When you make something confidential, by definition, some of the checks and balances, they disappear. Is that a good thing or is that a bad thing? I'll let you decide.
Right.
So, Landy, before, geez, we've been on the air 45 minutes already, and Miss G
Thank you.
hasn't said very much. Miss G, did you want to add anything?
I'm sorry, what?
Okay. Miss Cassandra, did you want to add anything this evening?
No. I'm sorry that a lot of your friends have CPS cases. It seems like that sucks.
It's just two, so we're trying to keep it that way. Right? What's the,
Go ahead.
no, you please.
Attorney Davis, real quick, can you kind of go over the trial? We were supposed to go over the trial today. There was a part of the trial that you said we were going to go over because we didn't finish last time.
What part was that? I don't recall. I apologize.
No, it's okay. Maybe I'm wrong, but like I'm always wrong, you know, in your eyes. But I could be wrong. Let me check my notes. But you did have something to say. Seriously, I remember because we were running out of time. But you said the trial is like several stages, right?
Well, every trial is divided up into at least, at the very least, 4 stages.
Okay.
Okay. The first stage is the opening. The second stage is the direct examination of witnesses.
Mm-hmm.
The third stage is the cross-examination of those witnesses by the parent.
Mm-hmm.
And the fourth stage is the parent presenting his or her witnesses and exhibits. And then, of course, the attorneys and the judge have the opportunity to cross-examine. And, of course, the last stage is the closing.
Is the closing the most important part of this?
In my mind, I mean, it's important. It's probably not the most important. The most important, generally, in these types of cases, is the cross-examination of the social worker that happens in stage like 3.
Do you think that with the cross-examination that people should be prepared to, for example, get copies of the social worker's report? You know, they have like a journal they keep like for every case.
Yeah, they're called delivered service logs.
Delivered service log. So that delivered service log, do you think is wise to get it for cross-examination purposes?
Yes, I do.
Okay. Now, when you request that service log, who do you request it from? Your court-appointed attorney? Your attorney in general, or do you request it from the supervisor or the caseworker?
You request it from your attorney, generally, and your attorney has to request it from the attorney from the social worker.
What if the attorney from the social worker, what if your court-appointed attorney tells you it's irrelevant, you don't need it, etc.?
It could be true. I don't know. You wouldn't know that unless you read them.
Of course, they haven't read them, but
Well, that's not really a correct assumption.
When it comes to my assumptions, I'm always correct. I just always wanted to say that.
He set you up. He
did. But honestly, I don't think they read it. I really don't think they read it. They don't. They really don't.
Georgette,
Yes.
In the legal field, it is a really bad strategy to assume something that you know nothing about.
Oh, God.
Really bad
We're
strategy.
talking about court-appointed attorneys, Vincent. That's who I'm talking about.
You don't know what they do and don't do. You don't.
That's okay. That's okay. That's okay. I'll give you that. I'll give you that. Okay. You
Look,
just think like
yeah,
I'm sorry.
your experience with your own court-appointed attorney was negative.
Okay, I'm
Okay.
not talking about that. We're not talking about that. I'm talking
Okay.
about in general. I'm talking about it overall general. They're all crazy.
Look at Macy. He's got a point.
Okay, Macy, that's fine. You go ahead, kiss up to Davis. That's fine. Kiss up to him. That's all good.
Macy, my girl.
Whatever.
What did they say? Oh, he's got a point. I was going to say, hey, since Vince started out as a court-appointed attorney, we know for a fact that there has to be at least one good one out there. Did I assume again?
Oh, I tell Georgette this, and she goes
Don't
off
say
like
my name right now. Just don't say it.
she
Okay?
goes off like a firecracker. Believe
Don't
it or
say
not,
my
there
name.
are good court-appointed attorneys.
They've got to
I'm
be
just
out there
saying.
if you were one.
Yeah,
That's all
I'm
I'm
just
saying.
saying. I'm just saying.
Good court-appointed attorneys in maybe criminal cases.
Of course, you laugh at Cassandra, but Georgette, GP.
I don't know about CPS cases, but
Yeah, thank you,
I've done a
Cassandra.
couple
Yeah,
criminal
yeah.
cases.
What about that? Is that an
Look
assumption?
what Kinsley's mommy says. I got one.
Well, good for you, Kinsley. God bless you and that person.
Anyway, we digress.
Okay, wait. There is a one question that they said that they have 45 days to investigate. I'm not sure. I thought an investigation is no longer than 30 days. So, love oneself. I don't know, where did you get the 45 days from? Am
Yeah,
I
my
right?
investigation started in June, and in mid-August, they sent a letter that said your investigation may be closed on August like 20th. But then we never got another letter, so I can just assume it's still open then.
Yeah.
That's a
So,
long time. That's way more than 45 days.
if it goes past 30 days, what's your feedback on that, Attorney Davis?
30 days does not mean 30 days. They can
30
generally
business days.
they can generally keep it open as long as they need to.
Wait, what?
So would it be smart for me to call the worker? And by the way, don't say my worker. They're not yours. The guy that contacted me, the social worker, should I be contacting him once more and just say, hey, can I get a letter that says the investigation has been closed?
You can. I usually like to lay low. Why bring it to their attention?
Right.
What are you going to do with the letter anyway?
Yeah, they could just
not
open up
damn
a new
thing.
investigation.
Right.
Yeah.
Exactly.
Okay. Thank you.
So basically, they can go more than 30 days, but can you argue that in court? Because I do recall reading it. You can argue in court about the 30 days if it goes beyond 30 days.
No, it's not a basis to help you get your child back. It's like one of those things. Well, they took my kid without a warrant. Oh, okay. That's the reaction you will get in juvenile court. Now, that doesn't mean you can't go across the street in federal court and sue them.
Ah.
But they're different worlds.
Yeah. Our government sucks. Yeah.
And what are you going to do about it?
I'm going to vote, Mr. Davis, and I'm going to start a rally in your name, in your honor. And I'm going to collect everyone in Orange County, Lancaster, Palmdale, LA County, and Sacramento. And we're going to go rally. And we're going to have your name on a big old thing. And we're going to be like, CPS.
Are you going to do that within my lifetime, or?
Yes, I'm going to do that within your lifetime, sir.
Are you
Nice.
willing to pick a date, make it real?
Yeah, Cassandra will make that happen for us.
Already pawning it off on Cassandra. Now we know. Now we know how serious you are.
I love you, Cassandra. Mwah. Yes, Cassandra and I are going to make that happen. With Cassandra's help, it's going to happen soon.
Okay, we'll see. Talk is cheap.
Okay, Marcy. Why didn't you join us then? You're Mr. Davis's fan. You agree with him and stuff. Making dates over. Yeah, come on, Marcy. Let's join the team. Join the team. Oh, let's do it. Cassandra, what do you think?
Oh, the 45-day person love oneself is from Massachusetts.
Ah,
You know, from every state to state, the rules are a little bit different.
but I
But
know
I
in
think,
California it's 30 days.
yeah, I think you're right. I think you are right about that.
I know I'm
But
right. I'm
but do
always
they
right.
but
I'm
do they ever
always
go?
right.
Do they ever go over 30 days? Did you take your medication today? Anyway, so
Wait, let me show you. Wait, hold on. This is what I've been eating all day long. This is it.
okay.
See, cinnamon fire candy.
Oh, really?
It's really
She's going cuckoo on the high fructose corn syrup.
Yeah,
yeah.
the high sugar.
Exactly.
Okay,
Hmm.
let me spoil
Hmm.
myself one day. One day.
Yeah.
I just had two. That's it. Look how small they are. Very small.
Right. All right.
That's okay. But look, we're gonna team up with Marcy and maybe love oneself in Massachusetts. There you go. I'm gonna travel there.
All right. Lori, Landy, I want to thank you for being on this evening, being a guest. Miss G, thank
Thank
you
you.
very much. Miss Cassandra, thank you very much. We're going to be on tomorrow night at 7 p.m. Miss Cassandra, what would you like to talk about tomorrow at 7 on our show?
I'm not sure. um, I don't know.
I have a
can't-
suggestion, if possible.
Go ahead, Landy.
Thank you. I'm just trying to nail down like the normal flow of a case. Like how long until the first hearing, how long until the second hearing. I've been writing notes, but I'm not quite sure about like I think I have the correct hearings in order that they usually happen, but I'm not sure if I have the exact or the dates, like how long it would be between them.
You
That
know,
makes
it
sense.
varies. I mean, there's a statute on each of them. But let me tell you this, Miss Landy, and I want to be sincere about this. You're asking the wrong questions. What you have to figure out is, how do I stop them from taking my kid? And what do I do once they take their kid, you take your child? What do I do to get the child back? The number of days in between each hearing, I mean, I get from a curiosity point of view, it could be important, but from a strategic point of view, those rules of timeliness are often ignored by both sides of the table.
Stretched out maybe, so
Yeah.
they
Now,
want to create that separation.
there's sometimes I want a case to extend further out. And there could be a lot of strategy reasons. Here's one of the strategies. My client was using drugs. I want them to get as many clean drug tests as possible.
Mm-hmm.
That can't happen under the statutory time frame.
Right.
Okay, so there's a lot of reasons to get it out there, extend it, or sometimes even pull it back to a shorter period of time.
Right.
I don't know if you know this, but in California, after the detention hearing, you're entitled to something called a no time waiver trial. And I think it's 15 court days. You're entitled to have a hearing, a full blown hearing in 15 court days.
So 15 days after detention.
15 court days.
court days. And can you repeat that, the type of hearing one more time, pretty please?
Jurisdictional hearing?
Oh, so 15 days after the jurisdictional, you can have a,
No time waiver trial.
thank you. So my heart just remembers when, back in June, when I found out they were going to investigate, my heart was like out of my body. I just, I can't even imagine having my kids actually taken from me. The amount of stress I went through, they're with me every day. So the amount of stress I went through just thinking about them being removed, my heart goes out to all those mamas and daddies that had that happen to them. Honestly, I do feel for you, even though it didn't happen to me. I was there with you, So I just want to not let an extra second go by that I could get back reunited with them. That's where I'm coming from.
Okay, I got it.
Yeah.
All right, folks, again, thank you for watching. We're way past our time.
Yeah.
Good night, all, and we'll see you tomorrow night at 7. And maybe Miss Cassandra or Miss G could think of a topic and message me tonight or tomorrow, and we'll try to cover that. Okay, I see Miss G raising her hand once again. And she has herself muted. Classic.
Look what Eric Santos wrote. Look what Eric Santos wrote. Laughing out loud, Miss G. We love you. Mr. Davis, be nice to Miss G, please.
Who put that up there? Let me take that down. Okay.
I'm calling in sick tomorrow. Have a nice day, everyone. God
Good
bless
night,
you.
everyone. And
Love you all.
Miss
Thank you.
Thank you, Miss Landy. Bye-bye.
Bye.
Bye.